Good afternoon. Thank you for coming. So my name is Gaston Alonso. I am the director of the Ethel R. Wolf Institute for the Humanities at Brooklyn College. And I am very excited and very honored to welcome you to today's event, State Courts New and Old, Guardians of Reproductive Rights and Other Civil Liberties, with Elizabeth Gleischer, Senior Consulting Attorney at Planned Parenthood Federation of America's Public Policy, Litigation, and Law Department. Please help me welcome her to Brooklyn College with a round of applause. We are incredibly honored that you've come to the college. Now, before that, I have a few quick things. First, I want to invite you all to join us during the first week of April, April 1st through the 4th, right here in the Tanger Auditorium. The Wolf Institute is going to be hosting a series of 8 public events organized to honor the work of historian Paul Ortiz, who is this year's Hess Scholar in Residence. We call it Hess Week. 25 speakers, 8 events, 4 days. Important discussions about academic freedom, the crisis of democracy, the role of movement solidarity and oral history in defending our freedoms and our democratic practices. At the door, you received a schedule for the week. We hope to see you. Please join us. Second, if you are not already doing so, please follow the Wolf Institute on our social media. To learn more about our upcoming programs, the link is also in the program you received. Third, if you're a student and you didn't sign in on the way in, please make sure that you sign in on the way out. And fourth, the event is being live streamed, and a recording of it will be housed in the Wolf Institute's YouTube channel. Now, with that, let me thank the sponsors of today's event. The Department of History, in collaboration with the Departments of English, Political Science, and Sociology, the Program in Women and Gender Studies, the LGBTQ+ Resource Center, the Brooklyn College Health Clinic, and the Brooklyn College Women's Center. They always send fabulous students to help us out. And now let me introduce the main organizer of the event, the person who dreamt this and dreamt putting us all together today, Professor David Troyansky from the History Department at Brooklyn College.
Thank you, Gaston. I am not a specialist in the judicial system or even in the study of the US. I'm a French historian, but I was a college classmate and friend of our speaker many, many years ago. And I received an email from her addressed to a small group of old friends announcing her retirement from the bench in Michigan and her taking up her current post with Planned Parenthood. I've been aware of her important rulings in the wake of the overturning of Roe v. Wade, but it was the fact that she'd be making periodic trips to New York City that led me to propose that she come out to Brooklyn College to give a talk. She quickly accepted, and here we are. Now, as a historian, I think a lot about time. There's the remarkably short time that it took for many people at the college to put together this event, from my department, from political science, sociology, women and gender studies, the Wolf Institute, etc. I saw the opportunity, but Naomi Brain and Anna Law were actually teaching in the relevant areas, so we see how faculty and staff and students can collaborate in a very timely fashion. But then there's the longer time of a career, something I actually do write about, though in a 19th century French context. And when I look back half a century, I ponder the twists and turns of the lives of my contemporaries, from college students to very senior practitioners in various fields, against the backdrop of a very dramatic, sometimes inspiring, sometimes depressing era of history. Elizabeth Gleischer's career in law and the judiciary has been marked by the great themes of contemporary history. I've been thinking particularly in terms of reproductive rights, but look at the headlines today, and they're about the intersection of federal and state law in the areas of migration, electoral politics, and any number of other things. Some of you may recall the words of a great 19th century thinker and revolutionary that the philosophers have only sought to understand the world. The point is to change it. My own career has certainly been about understanding. the world and explaining it to students and a reading public. I think already half a century ago, Elizabeth Gleischer, a fellow history student, was thinking about changing it. She's done that, and it's my pleasure to welcome her here to Brooklyn College.
Thank you, David, who I met in 1976, long before, 72, long before most of you were born. And I want to thank the sponsors of today's event. Thank you very much for not only inviting me, but for helping me construct the theme for this talk. It has given me an opportunity to think about these issues in ways that I haven't thought about them before. So let's get rid of me here. Can we, do I do the first slide, or can we get the first slide going? Let's see. That's the one thing they didn't tell me, how to start the program. That's perfect, great. And I've got a clicker.
Okay.
Okay. So this is a talk, as you can see, it's called State Courts, but this is a talk about three things.
Apparently,
Okay.
I'm not as technologically savvy as I thought. I started where?
No, this is the first one. This is good.
No, do slideshow and then start. Up there, slideshow. No, move to the right.
Oh, slideshow.
Yeah. And now from beginning.
There we go.
There we go. Great. Okay. Very good. I wouldn't know how to do it. When I teach, my students have to tell me what to do, so I don't know either. But anyway, this is a talk that's going to be about law, as you know. That's why you're here. But it's also going to be about history. It's going to be about law, history, and reproductive rights. And I certainly don't think of any of you as lawyers. Some of you are soon-to-be historians. But I think that it's very, very important to understand that we, all of us, whether we be lawyers, historians, or regular people, we cannot understand the struggle that's going on right now in this country about reproductive rights without understanding some history and some law. So at the risk of boring you a little bit or repeating what you probably learned either in college or in high school, we're going to do a little bit of a legal and historical review. To fight the fight, as I would say now, on the reproductive rights battlefield, as I'm doing at Planned Parenthood, we have to know where we came from. And that's what we're going to review a little of today. So let's see if I can do this. We're going to start with our founding document, the United States Constitution. As you probably learned in school, the Constitution does many, many things in this country. Important for this talk, it divides the power of government between the federal government and the state governments. And even more importantly for this talk, the Constitution includes the Bill of Rights. The Bill of Rights are the first 10 amendments to the Constitution. And the Constitution, as a matter of history, would not have been ratified by the states had it not been for the addition of the Bill of Rights, because the people who drafted the Constitution and who wanted it adopted by the states had to promise that the Bill of Rights would be added because they were afraid that the United States government would have too much power without the Bill of Rights. The Bill of Rights, we're going to actually start at the end of the Bill of Rights because those are the 9th and the 10th Amendments are the most important parts of the Bill of Rights, or two of the most important parts for this talk. State courts, as I'm going to continually stress to you, have their own powers. State courts are independent actors on the national stage. Why is that? That is in large part because of these two amendments, and I'm going to just repeat or talk a little bit about what those two amendments have to say to us today. The 9th Amendment, which doesn't get discussed very much by lawyers or by scholars, is I think, going to assume more importance in the coming years. I call this our constitutional safety net. This amendment, when you read it, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. This language means that we have fundamental rights as citizens and inhabitants of the United States beyond those that are identified or listed in the Bill of Rights. This amendment was specifically added, according to the historical record, because the people who ratified the Constitution were afraid that not every right could be listed in the Constitution. And without this safety net, the government could take over too many rights or trample on too many rights just because they weren't individually identified. So what the Ninth Amendment tells us is the Constitution was never meant to identify all of the rights that we have. So let me give you an example. The right to marry, for example. The right to marry is not in the Constitution. The right to have children. Neither of those rights is mentioned in the Constitution. But even the most Republican of judges would admit today that there is a right to marry and that there is a right to have children, even though they're not enumerated in the United States Constitution. And we're going to come back to that because it has a lot to tell us about the right to privacy. Okay, the 10th Amendment, and that's where we get started on the state courts and the power of the state courts. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. What does that mean? That means that the Constitution is a document that limits the power of the federal government to those things that are discussed and described in the Constitution, and all the other processes of government are left to the states. We have in the United States two systems of courts. We have the federal courts and the state courts. The federal courts, however, are courts of limited jurisdiction, and you can think of jurisdiction as power. The power to hear a case is the court's jurisdiction. Under the Constitution, federal courts have very limited powers. They're allowed to hear cases in which a federal question is presented, not a state law question, but a federal question, and cases in which the parties are diverse in terms of their citizenship, which we're not going to talk about today. But let me tell you an important statistic. State courts handle 98% of all the cases in this country. And I'm going to say it again. 98% of all the cases filed in the United States today are filed in state courts. State courts are the workhorses of the system. If you think about criminal law, for example, the vast, vast majority of criminal law prosecutions occur in state courts. Yes, federal court has provisions for punishment of certain crimes, but it's a very small number compared to the state courts. So what is a federal question? We've got that the states do most of the work when it comes to courts. But what do the federal courts do? Well, the federal courts are the only place that definitively interprets the United States Constitution. So state judges, like I was for 17 years, might have ideas and impressions about what other words in the Constitution have to say and what they mean. But the final word on the interpretation of the United States Constitution comes from the federal courts, and specifically from the Supreme Court of the United States. Federal courts interpret federal statutes, not state statutes, federal statutes. They resolve disputes between states, and they handle cases involving international law and treaties. And that's it. That's the limit of their jurisdiction. In the scheme of things, That's a very limited world for the federal courts. So what does all this have to do with reproductive justice, reproductive rights, and the right to privacy? Well, the right to privacy doesn't appear. Let me go back to that. The right to privacy, the word privacy, doesn't appear in the United States Constitution. Yet we know that the right to privacy is at the heart of many of the freedoms that we think we have, such as the right to marry, the right to have children, the right to have sex with whoever we want to have sex with, the right to, I hope, to reproductive justice. Where did the right to privacy come from? It came from the Bill of Rights. And we're going to go through exactly where it came from in terms of the Bill of Rights in a second, but I want to plant one other seed in your mind before we go there. Every state in the United States has a constitution. Every state constitution has an equivalent to the Bill of Rights. It may not, a state's constitution may not call it the Bill of Rights, but it has enumerated rights in every state that are either similar to or identical to the rights we're going to look at in a moment in the United States Constitution. And here's the important thing. A state constitution can identify a right to privacy as a right of the people within that state. And because we talked about federal questions, the federal courts can't touch that. That's not within the jurisdiction of the federal court. So if a state constitution says there's a right to privacy in our state, the federal courts have to stay out of it. All right, but we know, and I know, and maybe some of you know, that once upon a time, in fact, until January 24th, 2022, there was a recognition in this country for 50 years that there was a right to privacy in this country, and the case that most formally recognized the right to privacy was Roe versus Wade. But it's interesting when you think about privacy and you learn about privacy in the United States, that the idea of privacy actually came to the fore in an article written by someone, I think, from Brooklyn. I'm not sure where he was from, but he might have taught here, Justice Louis Brandeis. He was a presence. He was from Massachusetts, I think, but I think he did wind up here at some point. But Justice Louis Brandeis wrote an article in 1890, a legal article, in which he said that the people who founded the United States were all about one thing, and that was the right to be left alone, which he called the most comprehensive of rights and the most valued by civilized men. The right to privacy flows directly from what he became a justice on the U.S. Supreme Court, that idea. But it has been developed thanks to other provisions, the interpretation of other provisions in the United States Constitution, and we're just going to go through them quickly. Hopefully you've seen the First Amendment before, but the First Amendment creates a zone of privacy for all of us in terms of what we believe religiously, in terms of our religion, what we want to say, what we want to write, who we want to assemble with, that is, hang out with. Those are private choices that the First Amendment protects. The Fourth Amendment says our stuff can't be gotten into by the state, except if the state, the government, the police get a warrant. A warrant is a piece of paper that's signed by a judge saying there's probable cause to enter a home, a computer, a phone, any of those things. Our stuff is our stuff. The Constitution protects it as our private stuff. The Fifth Amendment, if you've heard about Miranda warnings, you have the right to remain silent, anything you say will be used against you. This is from the Fifth Amendment. We can't be compelled to speak against our will about anything, and we can't be deprived of life, liberty, or property without what's called due process of law. Starting about 70 years ago, these rights began to have new meaning with bunch of justices who were on the court beginning in the late 1950s, early 1960s. It was called the Warren Court, was led by a justice from California named Earl Warren. And the Warren Court did some remarkable things. It ended segregation imposed by law in schools, housing, other places. It dramatically broadened the civil rights and civil liberties of criminal defendants. It strengthened voting rights, bolstered freedom of speech and the press, and really gave some meaning to the two of the clauses in the Constitution, those for due process and equal protection. And importantly for us, in terms of reproductive rights, the Warren Court decided a case called Griswold versus Connecticut. Believe it or not, in the 1960s, the sale and use of contraceptives, birth control pills, everything else was illegal in the state of Connecticut. You could go to prison for using contraceptives. Estelle Griswold, who was the executive director of Planned Parenthood, was fined $100 for violating that law, and her case made it all the way to the Supreme Court, where 7 justices for the very first time said the Constitution does recognize a right to privacy. And in Griswold, they said that married people, it was confined to married people have a right of privacy that encompasses their ability to use contraceptives. Okay, where did that come from? The Supreme Court explained that various parts of the Bill of Rights, what we've gone over a minute ago, create what it called zones of privacy. And you looked at this just a couple seconds ago. The right of association, for example, contained in, the court used the word penumbra, which is sort of an area that's partly in light and partly in shadow, of the First Amendment, contributes to the right of privacy. The Third Amendment, which I didn't talk about, but prohibits quartering soldiers in any house in the time of peace, adds to the right of privacy, again, says we have privacy in our home. The Fourth Amendment, as I did talk about, says cops can't come into your house except with a warrant because that's your private place. The Fifth Amendment protects people from being forced to surrender their thoughts. And what the court said in Griswold ultimately was that there's a relationship lying within the zone of privacy created by this combination of the rights in the Constitution that says the government can't tell people whether to use or not to use contraceptives. And they did in 1972 extend the right to unmarried people. So that right got taken care of a few years later. What do we make of all of this? I think what we make of Griswold is that Griswold created a right of reproductive autonomy. It was about birth control, the right not to have children, but the flip side of that is the right to have children and to decide when, whether, and under what circumstances to have children. And Griswold is really the case that established that right. And that brings us to Roe. Roe in 1973 was decided by 7 justices out of 9. 7 out of 9 agreed with the decision in Roe, which is really quite remarkable because Roe was a very strong and powerful reiteration of Griswold and reapplication of Griswold in a very controversial subject, abortion. I review the facts here a little bit. The plaintiff, Norma McCorvey, was unmarried, struggling with alcohol and drug abuse. This was her 3rd pregnancy. She had given 2 children up for adoption. In Texas, the law prohibited abortion. Her lawyers sued to enable her to obtain an abortion. Meanwhile, she gave birth, but the case continued. And in 1973, 7 out of the 9 justices agreed that the Due Process Clause of the 14th Amendment, they said, implied a right to privacy that encompass the right to have an abortion. Now, the court allowed for limits on that right, if necessary, if there was a compelling state interest. And those are important magic words that lawyers and judges use, compelling state interest. What did that mean in Roe versus Wade? It meant, according to the court, that the state could prohibit abortion after fetal viability. So after the fetus could live outside the mother on its own, the state could prohibit abortion. But in other circumstances, if there were going to be other laws regulating abortion, the state had to show a compelling state interest, a very good reason for limiting access to abortion, given that women have a right to reproductive choice. Okay, but shortly after Roe, the war on abortion began. There was outrage about Roe. There was outrage in the Republican community, in the right wing of the legal community. We can talk another time about why people are so outraged about abortion. That's a different discussion. But almost immediately, states began passing laws all over the United States, requiring, the first wave required spousal consent for abortion. Now those got knocked down. Those got trampled on by the courts, which said there's no compelling state interest in a woman having to get her spouse's or boyfriend's permission to have an abortion. So those didn't go anywhere. But then the United States decided that it would withhold Medicaid funds for abortion so that poor women could not have access to abortion. And that was actually upheld by the United States Supreme Court. States began passing laws requiring parental notice of a minor's request for an abortion, and then shortly thereafter requiring actual parental consent. Most of those laws were upheld, and including by the United States Supreme Court, and imposing waiting periods for abortion, bans on abortions being performed anywhere outside hospitals, and bans on certain abortion methods. I was litigating abortion rights at that time. I was a young lawyer, and I was a volunteer lawyer for the ACLU of Michigan. And we challenged many of these laws in Michigan. Michigan had its own law prohibiting Medicaid funds, requiring parental consent, imposing waiting periods, requiring doctors to tell abortion patients lies about the risks and dangers of abortion. I will tell you that I lost every single case. Did not win one. We kept fighting, but that was the story of abortion litigation. It was like whack-a-mole. They would come up with one law, and they'd get that one. We would try to undo it. They were successful, and then they went at it a different way. And unfortunately, the history of the United States Supreme Court and abortion was a backing away from Roe. And again, I'm not going to go into the legal history of that, but case after case after case, the Supreme Court watered down the protections of Roe. So in the background, something was happening. In the background, some states had figured out that if there were to be any protection of a woman's right to choose, it would have to come from state courts interpreting state constitutions and state laws. That thought was beginning to germinate among activists within the states. But first, we have to talk about Dobbs. So Dobbs was the case that overruled Roe versus Wade, something that in my 70 years on the planet and 40-some years as a lawyer still strikes me as ultimately one of the most revolutionary acts a court could possibly take, because Roe was really, after 50 years, what we lawyers call settled law. Everyone accepted Roe except these activist judges on the United States Supreme Court. The case Dobbs was a case about a ban. Mississippi had banned abortions after 15 weeks, except in certain circumstances. And when the case went to the Supreme Court, there was hope in the reproductive justice community that the best we could hope for was that the court would uphold perhaps the 15-week ban, which is bad enough, but it wouldn't go any further than that. But the very activist court that we have today held there is no right to privacy in the United States Constitution. So they undid Griswold, although they didn't specifically say we're overruling Griswold. I think most people understand that they did. They also wrote, and this is the second most dangerous thing that they did, perhaps the first, I don't know, it's kind of a tie, that although there are some rights in the United States Constitution that aren't explicitly mentioned, they had to say that given the Ninth Amendment, they can't deny it, but they said from now on, in order to be recognized, those rights have to be deeply rooted in the nation's history and tradition. Let's take a moment here to think about what that means. Deeply rooted in the nation's history and tradition, meaning let's go back to the 1780s and 90s when the Constitution was drafted. What was the country's history and tradition at that point? It was white, heterosexual men were the only ones with any power, and half the country was in slavery. That's what we're back to? That's what this says, deeply rooted in the nation's history and tradition. So what about Griswold and the right to use contraception? What about the case that was decided in your lifetime, Obergefell versus Hodges, which gave gay people the right to marry? And what about Lawrence v. Texas, a case decided by the Supreme Court, which says gay people cannot be prosecuted for having sex? What about those cases? It's a big mystery. It's going to be interesting to see what this court does with those cases, because given that we are talking about rights that are deeply rooted in the nation's history and tradition, gay marriage is not such a right. The right to use contraception? Of course not. They didn't even know what contraception was. So where do we go with language like this that's now governing our ideas about civil rights? Okay, we go back to federalism. Here's our life raft. Here's our hope. Back to federalism. We have our 10th Amendment. All rights not given to the federal government are reserved to the people and the states. State constitutions, as I told you, have lists of guaranteed rights. Every state constitution has it. In fact, the Bill of Rights in our U.S. Constitution came from the Virginia Constitution, before Virginia was a state. And it's interesting, if you look at the language of the Virginia Constitution and you compare it to the United States Constitution, some of the language is identical. So states had their own constitutional rights long before the federal government did. State constitutions, we know from the 10th Amendment, are independent sources of power, which means that state courts are independently responsible for safeguarding the rights of the people. What does this mean in the real world? Here's what we lawyers say. We say the United States Constitution is the floor and the state constitutions are the ceiling. What do I mean by that? We have the 4th Amendment that says the right of the people to be secure in their houses and effects can't be abridged by the state, which means the state needs a warrant, right? I, as a state court judge, have to follow and abide by the warrant requirement in the Fourth Amendment. But in Michigan, we have another take on the Fourth Amendment. Our take, our state court, our state Supreme Court has said, and here's an example. Let me back up. So we have the Fourth Amendment, and we had in the 1980s something in Michigan. The state police began using sobriety check lanes, which were, if you were driving down the highway, the cops could stop you for no reason, just to see if you were drinking. No probable cause. You could be driving just perfectly, and they could do random checks for alcohol use. That case went all the way to the U.S. Supreme Court, and the Supreme Court said, under the Fourth Amendment, that's fine. I know about that case because my husband argued it in the United States Supreme Court and lost, another loser in my family. But so he lost that case in the U.S. Supreme Court. They upheld the constitutionality of under the Fourth Amendment of sobriety check lanes. Well, my husband, who was not to be denied, brought the case again, same case, in the Michigan Supreme Court, and said, Michigan Supreme Court, you need to interpret this case under the Michigan Constitution, and you need to find that sobriety check lanes are unconstitutional under the Michigan Constitution. And they did. So he won the case, and this is the 1980s. He won the case based on the Michigan Constitution. That he wasn't the only one using this little state constitutional law trick. A lot of lawyers had woken up to the fact that if you want to win on civil liberties issues, maybe you need to go to the state courts. The federal court is the floor, the federal court, but the states can do whatever they want. They are the ceiling. So this is sort of a review of what I just said, but state courts can review state constitutions any way they want, and the United States Supreme Court can't bother them. Their word is the final word on state constitutions. But what about cases in which the language of the constitutional right, let's say the First Amendment, let's say the state just copied it, word for word, from the U.S. Constitution. It says exactly the same words, exactly the same order. There is a doctrine that state courts have used that says we are going to be in lockstep with the Supreme Court. That they're saying if the Supreme Court interprets this language this way, we're going to follow them. But more and more Supreme Courts are breaking away from the lockstep method. They're saying, hey, no, we're independent actors on the legal stage. We're going to interpret our Constitution our way, even if it uses exactly the same language. And state courts can avoid the federal court or the Supreme Court becoming involved by making it clear that they are independently evaluating their own constitutions. We say adequate and independent state grounds for interpreting the Constitution. That's just fancy lawyer talk. Whoops. All right, so what are states doing? And in the rest of the talk, I want to give you some hope, I think, for what states are doing. Here's Hawaii. Now, yes, Hawaii is a new state, but we have in the Hawaii Constitution a specific recognition of the right of the people to privacy. So guess what? Abortion is legal in Hawaii and really unchallengeable given this constitutional provision. Believe it or not, Montana. Who would have thought Montana? I'm actually litigating in Montana now, so I know a lot about Montana. Never thought I would, but the Montana Constitution has a right to privacy, essential to the well-being of a free society. Kind of like, exactly like what Justice Brandeis said. They're copying him. California, one of the first states to be in the, no surprise there, to be in the forefront of privacy. And here's Michigan. Here's another take. I'm very proud of what our state did, because after Dobbs decided that there was no constitutional right to privacy, Michigan's 1931 law making abortion illegal came into effect. through a weird combination of circumstances, I turned out to be the judge who was assigned the case of whether or not the 1931 law was constitutional, and I struck it down under the Michigan Constitution and entered an injunction saying that doctors in Michigan could not be prosecuted for performing abortions. That held, it went up on appeal, of course, the other side appealed, but it held until November when we had a question on the ballot about adopting a new amendment to the Michigan Constitution that specifically provides every woman in Michigan, with every man too, with the right to reproductive freedom, reproductive choice. So my injunction, thank goodness, went away because it was no longer necessary, because we now have a constitutional provision in Michigan that protects reproductive rights. And you've probably read about fights that are going on all over the country right now with people in various states, Ohio, Pennsylvania, you name it, trying to get similar amendments on their into their constitution, and those are generating fights about, of all things, voting rights. And how do people use the right that they should have to get things on the ballot? Okay, how does New York do it? Since I'm presuming most of you are New Yorkers, I thought maybe I would include a slide about New York. New York has had for many years a law on the books, here it is, saying abortion is legal. Within, as long as it's within the patient's and the doctor's judgment, and as long as it's within 24 weeks, which is the viability threshold that was discussed in Roe. So here, New Yorkers are protected as well, and it's never been an issue here. All right, so what do you do if you're in a state where, and what are people doing in states where there isn't explicit constitutional protection, so there's not a privacy provision in the Constitution like there is in Hawaii, for example, or in California and Montana, and there's not an explicit protection in the Constitution like we have in Michigan. Here's what you do. You take what you've got in your state constitutions, and using the lessons learned in Griswold, in Roe, you argue that a right to privacy exists in the state constitution, even though it's not specifically enumerated, and that abortion is a fundamental right. And different lawyers and different cases in different states are characterizing this or talking about it in different ways. So it can be abortion as a fundamental right, it can be a right to privacy, it can be generally a right to bodily autonomy, meaning we get to decide what we do or don't do with our own bodies. What else is happening is that there are a lot of challenges now to bans of Medicaid funding. Those issues are being litigated again. And in a lot of states, in fact, I have a statistic on this. Hold on one second. How many states? 17 states, including New Jersey, and I think New York, yes, definitely including New York, have decided that states must fund Medicaid abortions. That comes either from the state Supreme Courts, holding that there's a right under another part of the Constitution we haven't really talked about, the Equal Protection Clause, or the Due Process Clause, to fund Medicaid abortions, but that's 17 states who went their own way in terms of Medicaid funding. I told you that the United States Supreme Court has upheld parental notice and consent and bias counseling. Many states have struck down those statutes under state constitutions. Montana, for example, last year struck down a statute that required that abortions be performed only by licensed physicians, instead of advanced practice nurses who were regularly dispensing abortion medication in Montana. The Supreme Court of California has struck down parental consent laws. So state courts can be very active about this. We've got problems, though. We've got problems on the horizon. As some of you may know, there's a case pending in the United States Supreme Court that's going to be argued very shortly about whether mifepristone, the drug, one of the two drugs that's used in medication abortion, was properly approved for use by the Food and Drug Administration, I don't know, 20 years ago, a long time ago. That's another subject. I could do a talk on that in and of itself. Most of the abortions performed in the United States today are in fact medication abortions. They're not procedural, they're performed using by people taking two different medications. Mifepristone is the first one. In addition to the Supreme Court of the United States possibly getting into this fight with regard to mifepristone and whether it was properly approved, we have an old statute on the books. It's a federal law from 1873. It prohibited mailing what Mr. Anthony Comstock thought of as obscene materials and contraceptives. Remember, I told you that the powers of the federal government are limited, but one thing the federal government does provide for us is mail. So under the Constitution, the Congress can make laws regarding the mail. And the Comstock Act is an act that says what can and cannot be mailed. The Comstock Act in 1873, and there's one mistake here because what they did say then as now is that mailing any article for causing unlawful abortion was also illegal in 1873, and today's Comstock Act is basically the same. It prohibits mailing any drug or medicine or any article whatsoever for the prevention of conception. We're going to come back to that in 1 second, or for causing unlawful abortion. Think about the fact that contraceptives under this act, which is still on the books and could be enforced, contraceptives cannot be mailed. I'm hoping there would be a little revolution about that. But the Comstock Act is definitely a potential problem. States, I want to end on a high note before I take your questions, but states are responding to all of this. Mostly blue states are responding by enacting shield laws. So what happens, let's play with this hypothetical for a minute. Let's say you're a woman in Texas where abortion is illegal and you want to have an abortion. So you go to a state where abortion is legal and you are prescribed the two-drug regimen for abortion, mifepristone and the second drug. You take the mifepristone in the state where abortion is legal, but you return to your home state to complete the abortion. Have you now violated the law of Texas by having an abortion in Texas? And can the doctor who prescribed the medication in, let's say, Michigan, be prosecuted for violating Texas law because the doctor knew you were going to go back to Texas to complete the abortion? There are a lot of very serious questions that are going to be coming to courts in the next few years regarding questions very much like that, like I've just posed to you. 15 states and the District of Columbia, led by Connecticut, have been proactive on that subject and have said, we're going to shield doctors and patients, but in Connecticut, for example, which is a state that allows abortion, we're going to shield doctors from helping patients in states where abortion is illegal by protecting them from prosecution. Should Texas come calling, we're going to say, you can't have any records, we're not going to extradite the doctors, we're not going to share any health information, and New York has a similar law saying we're not going to honor any of your subpoenas. A subpoena is an order to produce information, court order to produce information. All the states have laws saying we cooperate amongst each other with interstate subpoenas, New York has said, not on this subject. We're not going to cooperate when it comes to potentially prosecuting abortion providers in our state. So where are we now? We are in kind of a danger zone, a fraught place. We have states like Alabama saying that life begins at conception, even if conception takes place in a test tube. We still have states all over the country, mostly in the South, that have made it impossible for women of color and for poor women to obtain abortion services. We have states in which, frankly, you're not going to change the state legislature or the state Supreme Court, like Alabama, in my lifetime anyway. So you're going to have, the state courts are a place to have hope, but they're not the final answer. What's the final answer? Call me, wishful thinker or crazy, whatever you want. The final answer is to have an amendment to the United States Constitution that guarantees the right to bodily autonomy or privacy, or a recognition in federal law that abortion cannot be prohibited by a state. Are either of those things likely to happen in the very near future? You guys are the young people. You're the ones who can make it happen. So I'll leave it with that and welcome a dialogue with you. Any questions? Or comments or thoughts or disagreements?
And I'll do just
we have so many students here. I think it would be helpful if you just talk about how you came to your career.
Sure.
That would be so.
Sure. Some of them have heard this already, but when Professor Troyansky and I were at Carleton College in Minnesota, we both became history majors, and it was a time of great social and political upheaval. I said this before, but we're at the end of, or the sort of the middle end of the civil rights movement. And interestingly about me, I don't think he even knows this, but my parents were civil rights activists in Michigan, and in fact, there was an organization that formed in Michigan called Michigan Friends of the South, where people in Michigan, largely academics, my parents were not, but they were active, would help civil rights activists from all over the country get trained in integration techniques to go into the South and integrate restaurants, bars, hotels, buses, whatever. Rosa Parks, if you've heard of Rosa Parks, was somewhat involved in the training of civil rights activists to go to the South. My parents were very involved in Michigan Friends of the South, and what that meant for me personally, I was only about 8 or 9 years old, is that there would be young people from all over the country who would come to train, and my parents would put them up. They would stay at our house, which meant that my sister and I had to share a room whenever they were there, which made me very angry. So I'll confess my selfishness as a child, like we have them again. Why are you doing this? They're coming again. But now, of course, I think my parents were heroes. But that's the house that I grew up in. So I grew up in an environment where social justice and social change were very important. I went to Carleton. I majored in history because I believed that would be my best way to learn how to make historical arguments for social justice and social change. I went to Wayne State University Law School, which is a law school located in the middle of Detroit. This Brooklyn College reminds me a lot of Wayne State. After Wayne State, I was luckily hired by a law firm that did a lot of social justice work, and that's when I got involved in my ACLU work. I was doing other things too to make a few dollars, and I did that. I eventually left that firm and started my own firm, but I practiced for 27 years. And then a Democratic governor who I knew, just a combination of strange circumstances. There was a vacancy on the Michigan Court of Appeals, and she asked me to step in and take a seat on the Michigan Court of Appeals. So that's what I did. So I was on the Court of Appeals for 17 years. My term ends at the end of this year, which means, because I'm too old to run again, I'll be 70 in August, when under Michigan law you can't run for a judicial place if you're over 70. So I did what Ruth Bader Ginsburg did not do. I resigned so that I could give the governor of Michigan, Gretchen Whitmer, maybe some of you have heard of her, she's a very progressive Democratic governor, and I know Gretchen Whitmer, and I told her, I'm going to resign. You can pick my successor, but pick well. And she did. So I'm very happy with the woman who took my place on the Michigan Court of Appeals, and I knew when I was going to leave that I didn't want to stop working. I might be 70, but I'm not ready to check in, check out, I guess. Check out would be better. So I luckily got a position as a senior consultant, basically, for National Planned Parenthood and the litigation they're doing around the country. As I put it to them, I want to go back to my reproductive justice roots. So that's what I'm doing. So.
I could probably yell from the back of the room. Yes. So this may be taking us in a more depressing direction.
That's okay.
But I'm wondering whether, in your knowledge of what's happening sort of between states and in the realm of the state courts, is there a challenge to the SHIELD laws, a potential challenge to the SHIELD laws coming out of some of the states, Texas, Alabama, the governor of Florida, whose name is corrupted in various ways with theological implications. Some of those places which would then have the potential to kick it into the federal system as a dispute between states.
Absolutely. I think that's a real danger. I mean, I think that we do have a federal system which contemplates cooperation between the states. And when there is a dispute between the states, remember I said what the jurisdictional boundaries are for the federal courts? The federal courts have jurisdiction of disputes between the states. So if Texas sues Michigan, saying you did not produce the records of this abortion patient, even though we subpoenaed them in Texas, you have to do that. They're gonna file that case in the federal courts. So yeah, I think SHIELD laws are I'm hoping for the best, but we've got to hold our breath. The other interesting concept that brings up is that as lawyers, we have accepted for many, many years, I don't remember the case, but maybe even before I was born, that there's a right to travel in this country. There's a right to travel. The words right to travel are not in the United States Constitution either. But we've always assumed that all of us have a right to travel, which not only means going from state to state, but from moving, picking up and moving. A state can't stop us from doing that. What about the right to travel for an abortion? Can a state prohibit a resident of the state from traveling to an abortion state? I would think not. But again, I wouldn't have thought that Roe would have been overruled either. So, that's settled law, but maybe it all depends on what those old white men back at the time of the framing of the Constitution were thinking. I think they were in favor of the right to travel. That would be my analysis, as cursory as that might be.
What I have heard is that, and I don't, this is sort of what I've heard through reproductive justice anxiety pathways, let's put it that way, but it may not be just that, is that there's some concern that that some state prosecutors have tried to refer to fugitive slave laws.
I haven't heard that, but it doesn't shock me. Every day I read about new things that would once have shocked me, efforts to make, for example, I read yesterday that there's a new movement afoot among the anti-abortion forces to make it illegal when you have a fetal anomaly to have an abortion. They want to force women to have C-sections for fetal anomalies. They want to deliver, in other words, fetuses with anomalies, which talk about personal autonomy, bodily autonomy, that goes out the window. But that's a real thing. So it's hard not to be shocked.
Yeah. Other questions? Yes, go ahead. So for red states or blue enclaves within red states, what actions are being taken or will be taken to assure rights within that?
It's political at this point. In red states, it's about politically organizing to get referenda on the ballots of those states to either specifically create a recognized right to abortion or to amend the constitutions of those states to recognize the right to privacy. And many people in many states are trying to do that. And of course, coming up against resistance. I don't know if you followed Ohio, for example, but in Ohio, there was a referendum to put, I don't remember if it was reproductive rights specifically or privacy on the ballot as an amendment to the Ohio Constitution. And the Ohio legislature very baldly said, okay, we're going to change the law about what percentage of the votes you have to get, how many petition signatures, I guess, do you have to get a change of the Constitution on the ballot. I might be mixing up the goals here, but people are trying, here's the thing, people are trying in all of the red states to get this issue on the ballot. They're meeting resistance by state legislatures who are going to make it as hard as possible to get things on the ballot. So, but it's a political struggle. I don't know if that answers the question, but that's.
Professor Locke?
A comment and a question. Comment is, I am finishing a book on the right of mobility in the United States. I thought I was writing a historical book. I didn't know it was going to become relevant again. Because the book ends in the 19th century. But a question, Lisa, if you are a concerned citizen and you only have so many hours in the day and so much time and energy, where should I be putting my efforts? Should I be working at the local level and helping local level organizers? Should I be lobbying the national level senators? What should I be doing?
Good question. I think a combination of both. I think you guys are very lucky. All of you are New Yorkers, right? I'm talking, or even if some of you are from New Jersey, same story. Or Connecticut, same story. You're all lucky in that your legislatures are, for the most part, in the right place. But it never hurts to reinforce that these are my values, and I want you to respect my values as a voter. But keeping in touch with your national representatives and reiterating the same message, giving them courage, giving them strength, giving them money, is also, I think, very helpful. Monday morning quarterbacking is always easy, right? We can look back and say, how did we let Dobbs happen? How did we let the right win? And there's no easy or straightforward answer to that. Obviously, it's a combination of many, many things. But I think one takeaway that many of us have now is that we have to be organized, we have to be strident, we have to let the government know at every opportunity that we think this is, if not the most important issue on any ballot, which is my view, one of the most important issues on any ballot. And, just as a takeaway, my view is that women cannot be equal members of our society without reproductive rights, period. Maybe that's simplistic. I don't know. If it is, too bad. That's where I live on this issue.
And I think that's the message. I'm perfectly comfortable in communicating that to my representatives constantly.
Other comments, questions? Students? Perhaps we draw to a close, and we may want to ask questions of
Yeah, you can ask me privately if you want.
more personally. But thank you so much for coming to our
Thank you
college.
very much.
Thank you for sharing your story. Yes, thank you for sharing your story. Thank you for sharing your expertise, your smarts, your political savvy, and your inspiration, because there was inspiration despite living in these times. So thank you so much. You're always welcome to Brooklyn College. And thank you all for coming.
You're all welcome in Michigan.
Thank you.